Good afternoon, everyone. It looks like we are online now. We have invited the Special Rapporteur on the independence of judges and lawyers to be with us today for an hour of a discussion with the topic Corona crisis and challenges for the independence of the justice system. And before I will give you the floor, Mr. García-Sayán, let me briefly also introduce and name all other expert speakers and guests that are with us here in the discussion. So in alphabetic order, let me briefly name the experts that we have invited. We have Mr. Milan Antonijević from Serbia. He's a lawyer, human rights activist, and currently the director of Open Society Foundation in Serbia. We also have Mr. Dragoș Călin from Romania. Mr. Călin is a judge and co-president of the Forum of Judges of Romania. We have also invited Mr. Joran Daci from Albania. He is a professor, an attorney, and executive director of Albanian Rule of Law Center. We have already online Mr. Ion Guzun from Republic of Moldova. He's a co-founder and also legal officer at the Legal Resource Center of Moldova. We also have Ms. Remzie Istrefi. Good afternoon. She's from Kosovo and judge at the Constitutional Court of Kosovo, and at the same time also professor at Pristina State University. Good afternoon. We also have invited Mr. Mahir Muharemović. He's online with us from Bosnia. Mr. Muharemović is a former judge and currently working as research associate at CAS Rule of Law Program, Southeast Europe. Let me also welcome Ms. Andrea Posavec-Franić from Croatia. Ms. Franić is director of the Judicial Academy in Zagreb in Croatia. And we were just speaking about the webinars that the Academy is starting to host for judges in Croatia. Let me then also welcome Mr. Zoran Nečev from the Republic of North Macedonia. He heads the Center for EU Integration, and he's a senior researcher at the Institute for Democracy, Societas Civilis in Skopje. I want to also mention that we have invited Emir Prcanović from Bosnia and Herzegovina. He's executive director at the Association Vaša Prava, BIH, the Legal Aid Network. Next on my list is Mr. Stanislav Splavnik, who is online with us. He's a lawyer from the Republic of Moldova and recently joined our team at CAS Rule of Law Program Southeast Europe as research associate. And last but not least, we have invited Codru Vrabie. He's a Romanian trainer, an activist and consultant in the sphere of good governance. He's specializing on anti-corruption reforms in the justice system. That is something that has been widely discussed here in the past months and years. Well, without further ado, let me just say we are happy that you all joined, notwithstanding a certain Zoom fatigue, video conference fatigue that is already around after a confinement to home offices for most of us for the last almost 2 months. We are happy to have you, Mr. García-Sayán, with us, and I will not speak too much because you will now, before we go into discussion, briefly talk about your mandate. Let me just highlight that recently you also started a new webpage where more information in English and Spanish can be found. It's www.independence-judges-lawyers.org. And I will now give you the floor. We are happy to have you with us from Peru.
Thank you, Harmut. It's nice to have the possibility to meet all of you and to see again a couple of faces that we know each other already. And thank you for this invitation and for inviting this fantastic group of jurists of Eastern Europe. In a context in which, for all of us, it would be very difficult to imagine 3 or 4 months ago that we would be living in a world in which 90% of the population in this planet will be in countries in which their borders are already locked, a context in which we are obliged to keep the so-called social distances with other people, that even are close of us, and to wear masks all around the world, with the exception of one president that doesn't want to use this kind of protection. So we have never imagined that we would live in a context like this, that first has a direct social and economic impact that varies in each country, but that anyway is generalized in what matters to increase of unemployment, increase of poverty, and in many countries of hunger, which with specific additional impacts in migrant population, in women, and in children, in which in many countries are increasingly being victims of domestic violence in this context, in which some people feel certain level of impunity to act without existing judicial guarantees. Second is that in most of our countries, with that name or without that name, we are under some sort of a state of emergency, which has the legitimacy which comes from the need of political authorities to have better instruments to act and react regarding this virus, to gather and organize better the institutional apparatus, but at the same time has opened already some risks and I would say the minimum challenges, because in some occasions the executives are using these states of emergency powers to concentrate and excess power and to eliminate checks and balances and separation of powers, which opens the door to what we are going to discuss today, which has to do with the context in which, while in many cases the rights are restricted because of this prevailing states of emergency, guarantees and judicial guarantees to protect those rights when they are victim of abuses cannot be suspended, cannot be restricted, which is a major international standard that has been clearly established in treaties and by rulings of the European Court of Human Rights or the Inter-American Court of Human Rights. What happens with the justice system? Of course, I have used a wording that perhaps may sound exaggerated, but unfortunately is the reality in many countries, which is the paralysis of justice. Because of the fear of contagion of the virus, of the lack in many countries of the internet mechanisms provided so to follow up all the judicial files. In many countries, the judicial institutions are paralyzed, which opens obviously doors for abuses, which limits the possibility of using judicial guarantees like habeas corpus, or in Spanish it would be amparo or tutela in Colombia. So we are in a context in which all the priorities obviously are in the health system, how to prevent, how to apply tests, how to guarantee that in our hospitals, overcrowded already in most countries, there can be a possible appropriate attention to victims of this disease. So in many contexts, the justice system is left apart as if it wasn't an essential institution that whose functioning should be guaranteed at all times. That's a first challenge that we do have. Of course, pharmacies are open, hospitals are open, banks are open, but in many countries, only very specific actions by the judiciary are today taking place. So one first substantial comment is that the justice system should work, that it should receive all the political and institutional support to guarantee its functioning, and that among other criteria, one of them is that to have accountability of this eventually overwhelming concentrated power, an independent judiciary is absolutely essential. So in this context, 3 or 4 weeks ago, I issued a declaration as a special rapporteur, stating some points that from my approach are essential to consider and apply now, so that the citizens may have this guarantee of an independent judiciary even in these very critical circumstances. First is this principle that the judiciary should work, that it is essential, but at the same time acknowledge that in the context in which in most countries the electronic means to process judicial files is not already fully installed, that some priorities could be considered to establish at least certain possibilities that in areas that have to do with severe crimes, abuses committed by the political power, violence against women or children, labor conflicts that are some of the major things already occurring because many companies are collapsing and unemployment is a consequence after people being dismissed, in some cases illegally dismissed. So to concentrate in some sort of aspects that have to do first as immediate effects of the sanitary emergency, so that there is no need to review and to have all the old files, paper files that eventually may not be accessible for all judges and prosecutors. So that was one of the first actions in which we have found not necessarily a big activity, because in many cases, judiciary say, well, we are trying to do so-and-so, but we don't have yet the electronic means to properly function without reviewing physically the files which are in buildings that are right now closed because of the lockdowns. Second, a substantial aspect which has to do with the content, so that has to do, that depends of the national regulations, special attention by judges or by prosecutors or by both at the same time. So to promote an increasing use of electronic means to report abuses against human rights, to report violence against women or children, and to have the possibility that the judicial authorities as a whole, which may include in some countries prosecutors, can have the possibility to act and react. So at this stage, innovation and development in online technology, which may have been before this crisis a concern mainly of very specific groups inside our judiciaries, today is an essential step that must be taken, so to guarantee that this paralysis that in a way may exist because of sanitarianism doesn't affect so severely human rights. Third, what is today one of the major challenges for health and for human rights and for the right to life is the rights of incarcerated people, which in most countries, that's clearly the case in Latin America, in which about 30, even 50% of the incarcerated population is not yet a convicted population, but only being still prosecuted. But in any case, in most countries, overpopulated without the proper sanitary conditions. So many incarcerated people are getting sick, many are dying, and that occurs not only in Latin American countries or in poor countries. The last news being reported today by New York Times is that more than 1,200 people working in the New York prison system are already sick, and many in prisons in New York City. This figure is the New York State. In the figures in New York City, prisons, not less than 10% of the prison population in New York City are already sick. Imagine what would be the situation now in countries like Peru, in which when one of the biggest prisons there, a test was made to 1,200 of the prisoners in that prison, which is much bigger, more than 60% of them were sick. So all this is a matter that has to do with political decisions, but in many cases has to do with judicial decisions, decisions by prosecutors, while it seems that in most countries, politicians, governments, or congresses are in a way reluctant to act very strongly in this matter, which is a matter which is not easily raising sympathies in the population that, of course, fears that this may increase crimes in the society. Two countries that have taken dramatic steps in the last weeks, releasing more than 40% of their population, are countries that are not necessarily models of democracy, which are Turkey and Iran, in which they have really dramatically taken that decision, of course, not releasing political prisoners. And fourth, one last but not least aspect, which is very important, is that while there is big concern in most of our countries about the sanitary conditions of the specialized people that are playing a crucial role to react against this crisis, which are people working in the sanitary area, beginning with doctors, members of the police, firemen, etc. This special protection should be part, of course, of a context in which judges, prosecutors, and judicial personnel should receive this kind of special protection, sanitary protection, so that the courts, the judicial areas can work perhaps not as usual as before, but recalling first that this is an essential component of any society, not only doctors or police or firemen, but and at the same time that all this context should be a context in which we should use again the basic principles of independence of justice, which are achieving 35 years when they were adopted by the UN 35 years ago. So this is the the first comment that I want to make, Hartmut, and I am of course open to questions and especially to suggestions and ideas on how this role can be strengthened in a context in which this paralysis obviously includes the United Nations, includes the support office in Geneva, in which everybody is working in their homes. The next big session of the Human Rights Council is supposed to take place next month in Geneva, and believe it or not, being almost at the end of May, we, the rapporteurs, the countries have not yet any information if this council will take place by internet or not. Obviously, a regular session is impossible because for most people will be impossible to arrive to Geneva from whatever places they are based. So thank you, Hartmut. And again, thank you for this fantastic possibility to meet with you today.
Thank you very much. We all can switch on our cameras again, and we are live on Facebook. In my very brief introduction, I have even forgotten to mention that prior to your mandate as the Special Rapporteur on Independence of Judges and Lawyers, you have been President of the Inter-American Court. You have been working also for the United Nations, the Organization of American States, and in your home country, in Peru, you served as the Minister of Justice and Minister of Foreign Affairs. But you also take great interest in our region, if I may say so. You have been to Southeast European countries. You have been invited to travel again. Let's hope it will be possible soon again for you to be either on official visit or on academic visit in one of the countries of Southeast Europe. And just for you as a reiteration, and also those who follow us on Facebook, we, as CAS Rule of Law program, work in 10 countries here in Southeast Europe, them being Montenegro, Bulgaria, Serbia, Romania, where you have been, Albania, Republic of Moldova, Kosovo as well, North Macedonia, Croatia, and I hope Bosnia and Herzegovina. Last but not least. We have great interest in your work. We have been speaking with the experts, and I don't want to take too much time and want to give the opportunity to everybody gathered here in our virtual roundtable to raise at least a question. But indeed, I can also only confirm that there is huge challenges for the justice system, be it criminal cases that could not be finished on time due to the basically lockdown of courthouses in some country. In civil cases, the statutory period of limitation had to be dealt with in some cases, some countries. It was prolonged for the duration of the crisis situation. So a load of judicial questions. But with that, I shall be tasted now and want to open the floor to our experts to raise questions to the Special Rapporteur. Please. Who would like to start? Is there any immediate questions that you would like to direct to Special Rapporteur García-Sayán? Yes, we have, I see two hands. Okay, I will be moderating. Ms. Franic from Zagreb. Please switch on your microphone.
Well, good morning, Mr. García-Sayán. It's a pleasure and an honor to be in this online discussion with you. I'm interested in the independence of judges, and this Corona crisis jeopardized independence of judges in a way. But judges are some kind of protection or guarantee for the rule of law and human rights. So my question would be, what judges could do as a profession to protect their independence? What could they do by themselves? What wouldn't depend on other branches of power? I mean, executive and legislative part. Thank you.
The microphone.
Thank you, Andrea. It's a very difficult question because it sounds simple, but it is not simple. It's a very difficult question because the usual things that judges should do or are doing already to protect their independence is to protect the principles that sustain their independence, which has to do with the process of appointments, with the process of promotion, with the stability in their functions, and all of them so that the proper procedures are followed and not political criteria, but technical, professional criteria. Of course, this is a thing that the formula may be already expressed in the basic principles adopted in 1985, but usually there are many challenges and threats. The threats that may come in almost all countries in the world in different moments and circumstances, from the temptations of the political power to control the judiciary, which is a kind of a genetic temptation of political power worldwide that works if there are institutional conditions that doesn't impede the political power to fall in that temptation. But as well, there are other challenges which are not mentioned even in the basic principles adopted in 1985, because that was a context in which corruption was thought as a kind of internal matter of the state. Right now, corruption is an international matter. There's a fantastic convention in the UN against corruption, which is one of the most relevant and substantial treaties adopted in the last decades in the United Nations, by which we must consider as well that corruption may be another threat that can affect independence of justice, not coming necessarily from the political power, because in some cases, organized corruption can be even stronger than certain governments in several countries. So this general view, in a way, aggravates in the context of emergency we are living now. And I am thinking right now in a couple of examples of countries in which using emergency powers, there is a kind of big concentrated possibilities by governments to take decisions regarding acquisitions of medicine, acquisition of tests, money for investments in the improving conditions of the health system, and so on, in which already, when there is a free press, the societies are being informed of big cases of corruption already taking place, and this process of extraordinary expenses to react against COVID-19. So again, we are in a question in which, besides specifics, the basic principles that the judiciary in this context must be independent from political power and must be really aware from this attack and threat coming from organized corruption and from corruption as a whole is more relevant than ever. Under no circumstances, my feeling is that these extraordinary powers being right now assumed by executive powers, that those powers can be extended to the control of the judiciary. That wouldn't be acceptable. But at the same time, is it important that the administration of the judiciaries, which in many cases depends on the Supreme Court or whatever system each country has, that they are attuned with the demands of society. Because if everybody begins to do telework in their houses, ministers, congresspeople, mayors, doctors, and so on, but the judiciary maintains traditional, only paperwork, only lengthy procedures, obviously that generates the temptations from the political power to say the judiciary, hey, you are living in a context in which you must do telework, you must react, you must act, you must do something. So I think this challenge, which is not easy to follow, how to modernize with appropriate technology very complex judicial procedures, which is not an easy thing to do. I have seen in Uzbekistan last year in my visit how there is an important project to do that, at least in the civil area, not yet in the criminal. Of course, that's not a matter that can be built in 2 or 3 months, but this is a question in which a priority to be tuned to the needs of the 21st century in this severe crisis is a matter in which the independence and autonomy of the judiciaries are receiving an additional challenge. I hope, Andrea, this gives a response to your very, very important question.
If I'm correctly informed, there was a hand raised by Judge Istrefi, and I see your hand, Mr. Antonijević, and Mr. Călin, you shall be next. Judge Istrefi, the floor is yours.
Thank you very much, Hartmut. Thank you very much, Mr. Diego Garcia. It's such an honor for me, and I believe for all of us, to be here in your presence and to listen about your extensive experience. I am very much interested to learn from you about the experiences and related to the role of the media in the independence of judiciary. In fact, I would love to hear from your opinion related to how to balance the need for the media to report about the high-level cases, especially related in the times of emergency when it comes to the issue of constitutional review of human rights, but also the tension that this reporting is bringing into the independence of judiciary. So I would love to hear your opinion and also other experiences, because I think you are very well positioned to do so. Thank you very much again.
Thank you. For me, an honor to have you this morning dash afternoon in this meeting. It's a very challenging matter, actually, and difficult one, because it has two sides, as many parts of the real world. By one side, a free media, an independent media, is obviously an absolutely crucial element in a democratic society. To be informed of what is going on, to have different views of what is happening and what could happen in the world, or in our country, to have the possibility to monitor critical situations, to have, for instance, one of the best ways through which societies can be informed about abuses, about corruption. And if one follows, for instance, how this process of discovering of this big organized corruption by some Brazilian construction companies that has covered most Latin American countries in the last years, the best way through which societies, and eventually after that, prosecutors and judges were informed about this, was through investigations made by journalists, things published by the media. So this has been and will continue to be a crucial element of a democratic society. But at the same time, there's a fact that I guess may occur in all of your countries, or in most of them, is that in some cases there is a process in which perhaps the word would be substitution, in which the front page of a journal or a campaign made by the electronic media generates a context in which obviously seems that the rulings are already taken by these kind of front pages, using the word front pages covering everything, printed papers, Twitters, and so on, in which a concern I really have is that in many cases in which judiciaries don't have a necessarily long tradition of strength and independence, in many cases, certain individuals in the judiciary as a whole feel in a way limited themselves to act in contradiction to that common sense that has been created by these front pages, by this campaign of the media. No? So it's a matter in which it's difficult to find what will be the best way to respond. Because obviously I am against any kind of censorship that would say you cannot say that sort of things, which is a threat that already is occurring in a couple of countries in Latin America using this state of emergency powers, Bolivia or El Salvador. You cannot create anguish in the population. You cannot do so and so and so. Well, when you begin with that, that opens the route for the control of freedom of expression. But at the same time, I think that one very important step would be to promote a permanent dialogue between the people being placed in the judiciary as a whole and people having a key role in the media to say that, well, whatever thing you want to say, you can say it, but don't substitute in which the convictions of a person that perhaps can be innocent, or in which the process has just begun, in which there is no proof yet to convicted person, that decision has been already taken by the front page of a newspaper. And if the judge or the prosecutor doesn't follow that sacred decision already been announced in that front page, that person will be victim of a campaign. And that has happened not only in national courts. I have seen that in the media. This is a private meeting, some British newspapers against judges of the European Court of Human Rights. Even a campaign that affected the British judge made by British media, using the pretext that the last name of this British judge doesn't sound very British. His name, he's not anymore judge of the court, Nicholas Bratza, and it say the front page, Bratza, who's Bratza? He says he's British, he cannot be British with that last name. Happens that his father was from the Czech Republic or Czechoslovakia, I don't know. So in any case, that I would favor very strongly this democratic dialogue, so to minimize these temptations by which Twitter or by a front line, you can suffer the temptation to control what the judges, independent judges, can do.
Thank you for answering our second question. At the risk of jumping from one topic to the other, but there are so many things concerned, I will now immediately take the third question. I have seen your hand, Mr. Antonijević. You are with us from Serbia, please.
I would like to thank the Special Rapporteur on this occasion, and also to thank you for your timely intervention, not only speaking with us, but also the document that you produced with 7 crucial aspects for the independence of judges and lawyers. It's very useful. I would like to draw your attention to one of the things that's happening. It's not, I think, limited only to our region, and that's the usage of a court system in cases against those who are violating any of the newly introduced rules during the COVID crisis, along with the pressure that's is asserted by executive power. This really creates a very strange environment for judges, also for lawyers. There are cases in which you really have a speedy trial, a Skype case. So what would be your response to that? How to really safeguard the rights of both the judges and the lawyers, and of course those who are incarcerated. In some of the cases, those who are incarcerated doesn't have the right to use Skype trials. They're used only for those who are violating the strict newly introduced rules during curfews or during any response to COVID. Thank you.
Thank you, Milan. Very important matter, because that leads us to perhaps two aspects which are very important. First, the democratic context that the international standards has already fixed by agreement of all countries of states of emergency, in which states of emergency has to be proportional to the need to have, they may have always have judicial guarantees, and not have, it shouldn't be a door open to excesses. So when one follows what in some countries is occurring, I will give the example of El Salvador, in which the people captured violating the lockdown are in prison for 30 days. In places in which the possibility of getting sick are 9/10. So it has no rationale in which the role of the judges and the prosecutor, regardless if the law says you can be there 30 days, that has an excess regarding the needs of a state of emergency. So first, the definition of a state of emergency doesn't mean, according to the International Covenant on Political Rights, the European Agreement, the Inter-American Human Rights Convention, doesn't mean absolute power to the political to the executive. And at the same time, that judicial guarantees should be respected and maintained. And one of the rationales would be, of course, first, if the level of the repression taking place, for instance, imprisoning a person for 30 days has no sense, it has no logic, because that person will get sick, of course. No? So that's a way in which I would say a strengthening of the independence will be absolutely crucial. Who will fix if the judges can have the possibility to act or not is not the ruling of the state of emergency taken in that specific country, which eventually the government may follow their own temptation to say, to limit this judicial control. We must go directly to the international standards. In international standards that establish that the judicial guarantees maintain themselves 100% during that state of emergency, the state of exception. So these are questions in which what I have seen in several places, which is so amazing, in which the police is supposed to capture people violating the lockdown. Of course, people violating the lockdown must suffer some kind of action by the authorities, some fine, some call of attention, something, but not necessarily taken there to the prison. What happens then? They see a guy walking in the street, so they capture him or her, they put her or him in the police car, which is crowded with other people being detained in the street, crowded with police, and everybody gets sick. So that has it's a question that has to do not with judicial aspect, but the common sense. So in this aspect, I will be absolutely radical to say that it is an absolutely crucial moment to strengthen the conscience among judges, prosecutors, that states of emergency doesn't impede their action, and that by the contrary, that it places an actual and very relevant challenge, that the only counterbalance that society may have in a context in which people are limited to make public protests or so on is with the power of the judges and prosecutors. Thank you, Milan.
Thank you. Very brief. I have two more questions here on my list. Next is Judge Călin from Romania, please.
Mr. García-Sayán, I want to ask you something about corruption, because you said that the state of emergency does not mean establishing impunity for corruption or for other offenses in connection with procurement of medical equipment. And also, the Venice Commission has stated that even in genuine cases of emergency situations, the rule of law must prevail. Also, Greco, the group of states against corruption, warned of the increased risk of corruption in the context of the health emergency caused by the pandemic of COVID-19. In this context, in Romania, for example, the Secretary of State in the Ministry of Internal Affairs, having a central role in crisis management, because the government was exercised during this period by issuing military ordinance, said the following, and I want to read: whoever has avoided the bureaucracy now for health procurement should not be punished. If we tackle on the opportunity, on the fact that someone did not follow a rule or went faster to solve a problem, then we have a big problem. No one will do anything in the future. I want to ask you if statements like this can undermine the independence of judiciary. Thank you.
An amazing declaration, by the way. That's not consistent with not only common sense, but not consistent with should be the role of any public authority regarding a context in which obviously if emergency powers exist and that could be used for extraordinary expenses, that will be in Romania, Peru, Brazil, or Finland, temptation and risk of corruption. So if at the same time you are impeding the action of what can be broadly the judicial authorities, that means prosecutors or judges, you are in a way convening corruption. And that is not only against the elements, the basic elements of a democratic society, but at the same time against a specific ruling, a specific components of the International Convention Against Corruption that oblige the member states. All of our countries represented here are party of this in Convention Against Corruption that oblige to prevent and to take actions against corruption. Of course, there is not a specific mechanism of sanction in this convention against countries that do not follow necessarily that rule. But of course, that obliges the judges and prosecutors nationally to follow the standards of the Convention Against Corruption, in which judges and prosecutors receive very clear and specific functions to follow, not only in their countries, but to establish international cooperation among them. For instance, a prosecutor, which is following a case in Romania, but eventually a public prosecutor in Peru considers that that case of corruption is connected to things that have occurring in Peru, I, the prosecutor in Peru, can receive from you, prosecutor in Bucharest, all that information without going through the diplomatic channels of the government and so on. So there's a kind of a specific autonomous rule which generates obligations and rights to public prosecutors and judges, in which I would I should have more information about the example you are placing, but in any case, the judges and prosecutors have the possibility to interpret in favor of rule of law, in favor of international treaties, internal regulations that are contradictory to that standards and to that treaty. So I think that example you have mentioned is absolutely amazing, in which that will be in any country in the world that should be read as a door to impunity and a door to corruption and of undermining the function of judges and function which is unacceptable internationally.
Mr. García-Sayán, we have now had 3 questions from judges, one from an attorney. Your mandate covers both judges and lawyers. So I'm now giving the floor a lawyer from the Republic of Moldova, Mr. Ion Guzun, directly followed by another attorney from Albania who also has a good question.
Excellency, dear colleagues, thank you for your interest and time on independence of judges and lawyers in the Southeast Europe. Due to various restrictive measures imposed during the COVID-19 pandemic, courts around the world had to significantly reduce the number of court hearings. Various challenges arise in the context of remote conduct of hearings related to the defendant's rights to a fair trial, limited financial resources to digitalize courts, along with the lack of legal framework to ensure online court hearings, at least in criminal cases. Are you consider to develop and issue a set of urgent recommendations, along with other relevant regional institutions, to ensure remote conduct of hearings, the fair trial standards during the COVID-19 pandemic, and the uniform application of the relevant standards? Thank you.
Do I wait for the other question? Because I understood from you, Harmo, that there will be 2 questions together?
No, question by question. Yeah.
Okay.
Your microphone is switched off.
Guzun, thank you, but your communication was not 100% perfect, so perhaps I have not followed it completely. But in any case, when yeah, okay. The proceedings, if we are using, for instance, electronic means, their legitimacy, their legality is based in following the proper procedures. No? Because if the judicial guarantees are not completely followed, in the case of lawyer support, access to proofs, and so on, this way in which the modernization of the judiciary takes place can be a way through which we could be undermining due process and undermining judicial guarantee. We see, which is a problem which is very, very complex, because if judges are most of them locked in their houses, they have no physical access to the files. How can they have hearings if they don't have all the information? So it is absolutely essential that special rules, transitional rules, are adopted, which are functional, because I have seen in some cases in which you see a magic response in which all things should be done electronically. But if you see the reality in that country, in which they don't have even computers in some cases, in which the connections by internet are a disaster, that doesn't work. So it must be a case in which perhaps many of the processes in this difficult context are in a way blocked. They are not moving on. And of course, all that has to do with the terms, the periods of, so they go, can be in a way frozen as well. No? So if one follows what has been adopted, for instance, by the government of Spain to rule with electronic means, this kind of criminal procedures, at the end of the day, at the end of the text, you discover that that doesn't function, that is not working on now. No? So if I have understood your question, that would be my answer at this stage.
Thank you very much. As I said before, we are now taking on a question from an attorney at law from Tirana, Albania. Mr. Daci, please.
He has the microphone off.
Jordan, Mr. Daci, can you please switch on your microphone? We cannot hear you.
Okay. I thought you switched me off. Okay, so I'm sorry for calling you from my car, but I just got out from a quite long court hearing dealing with some arrests that have been done to people protesting in last days in Tirana due to demolition of a national theater. But now there is another protest ongoing. So although we are still formally under lockdown, people now just don't care. They are just protesting. But at the same time, the government is arresting like massively. And the court now has to deal with whether, because Albania formally has also derogated from some articles of European Convention of Human Rights, as well as the state of natural disaster has been set, and it has been prolonged until middle of June, until 23. So the whole question now for judges who are under the pressure of the government for maintaining people under arrest. Meantime, still people, they just don't care now, is becoming massive. So my concern is that basically in recent days, especially, there is a huge dispute about court opening, because although now we have opened all the activities, only the courts are not open, and it seems like the government, which is for the first time, the government with its own act decided to close the court, although this act has been passed in the parliament within 45 days, but still, I think, to my understanding, it was unusual that the executive branch decides to close the judiciary branch, although we have an independent judiciary governance body who is supposed to take this decision. So my question to Mr. Garcia and to the rest of the public, I know, for example, Milan, so hello, Milan, basically is that what's the situation right now in other countries? To my understanding, I don't know, but Albania has closed the court and they work only for some urgency matters, but to be honest, judges are those who decide whether your case is urgent or not. Although you may really have a urgent case, and because they don't accept people to appear before the court, but you need to use mail, your urgency may need to wait maybe several days until your post reaches the judge and the judge reads it. So I don't know whether you find it appropriate and whether other countries have better experiences in regards to courts during this time. Thank you.
Thank you for your question and for your information, because I was not aware, to be frank, about how deep was this, I would call it, attack against the independence of the judiciary following the information you are just providing us, limiting severely its function, because what may happen in other countries is that this, under the state of emergency, is the judiciary itself that regulates what they can do or what they can't do in this context of sanitary emergency and risk. No? So that is happening in several countries in Latin America and Spain, in many European countries. So that should be organized. That is part of the independence of the judiciary, its handling, its management, well, how they can work during a state of emergency. That's to be decided by the judiciary. In many cases, there's a very conservative approach. We cannot do anything because we can get sick. All the files are in paper, so let's wait and see. So that's one of the first topics. The second is a thing that you mentioned, Jordan, is that certain provisions of the European Convention on Human Rights has been abrogated by somebody, by the Congress or by the government. That's unacceptable. That violates international law. That cannot be
derogated.
Derogated.
Not abrogated. Derogated. Yes.
Derogated. It's the same, because obviously a convention cannot be derogated by the political decision of one of the components. It's an agreement taken by a conjunction of countries, and only can be changed, can be derogated partially or totally by agreement of the components that generated that convention. So that by itself, in this context, when there is kind of a concentration of power limiting the independence of the tribunals, and especially if they are intruding themselves in a thing in which a national government cannot be, hasn't the power to derogate any provision of an international treaty, of course, that could be a matter that a case can be presented, and I hope open in the international court to follow up what are the limits or what are the possibilities of governments in a state of emergency. So we are returning to the basic. A state of emergency is not the lack of rule of law, but a specific way through which rule of law works, in which the component of a functioning judiciary is a component that couldn't and shouldn't be deleted ever. No? And if the Convention of Human Rights exists, in which any country can derogate an article or a provision of that Treaty of Human Rights, that would be the end of international law. So that's a matter that can be very severely considered a matter of presentation of a case in the European Court.
Let me also...
Just to inform you, just 1 second, please, Helmut. Situation in Albania is very unique because we don't have a working constitutional court and we don't have even a working Supreme Court. So the situation is really a mess. Thank you.
Thank you.
I also wanted to say thank you for bringing in a real life example, a recent one. You said you just stepped out of courthouse to defend one of your clients. Thank you, because the issues we are discussing are not mere theory, but the legal landscape is changing as we speak. I would now, although we are coming close to the end of our discussion, I would like to give Emir Prucanović from Bosnia and Herzegovina the floor to also have some information and a question coming from Bosnia and Herzegovina. And then Mr. García-Sayán, it will be up to you to decide whether you can stay for another question afterwards or whether we have to end the session. Mr. Prucanović, the floor is yours. We cannot hear you.
No.
There is a technical issue.
Can you hear me now? I didn't have any problems until I unmuted. I don't know if you hear me now.
Can I propose you raise your question in the chat, and then I will read it out to Mr. García-Sayán, if that is an option.
Okay. I don't know, can you hear me now?
Not very well, but yes, if you speak very loud, I guess we can. Can you repeat your question, please?
Yes. Well, the question, number one, first of all, thank you very much for the opportunity to raise certain issues. My question will be brief, and it's related to the situation of hampering, in general, independence of judiciary. We all know, at least in situation in Bosnia, how many people are even journalists, which is part of the question that is basically leaning on the Madame Remzie Istrefi from Kosovo's issue that she raised. We are all aware the number of people and even journalists openly talking about and questioning the independence of judiciary. Some judges, let's say, raising open discussion and basically naming them as the ones that are politically correct, who follow the strict political dictate, etc., raising the issue in general of the judiciary independence. On the other hand, we see that situation that the lockdown introduced by the state's measure has brought certain issues also to working or continuing work of the courts in the country. Now, we don't see that much of the transparent work, so to say, and transparent relation between the courts and prosecutor's office and the general public, so to say. So my question would be, how important is to have specifically tailored communication strategies, at least for the courts and prosecutor's office, to openly address all of these pending issues? Because we are definitely aware, for example, the article that I read during this conversation, I actually saw the article saying that judge who is politically appointed judge, blah, 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 is actually doing nothing. They seized the opportunity for this 2 months lockdown to do nothing, although they were doing nothing prior to this lockdown. So I think that this communication strategy should be at least important part to have in all of the institutions, and in general, the position how by Mr. Garcia, how communication strategy would basically improve the transparency of the work, and etc. Are there any positive examples? I know there are, but are there any positive examples to talk about?
I whether you have properly heard all of the question, Mr. García-Sayán. So let me therefore repeat some key elements of the question. It is related, just as the second question we had in the discussion, very much to the media, to the work of journalists. And if I understand Mr. Prcanović correctly, then the question is how important are communication strategies to address certain issues, judges being attacked in the media, such as rumors that the judge has been politically appointed, and also are there any positive examples that you can add in so far? That has been the key question.
Thank you. I don't recall at this moment a positive example, but allow me to make a general comment. Really, what you have mentioned, communication strategy is really important, because the public in general, in most countries, feel that they are really distant from the judiciary, whose procedures, whose lengthy procedures are for most people very difficult to understand and accept. So a communication strategy is important, but specifically in this emergency situation, to explain where and how the public can use the judiciary when they have an emergency. So that is very challenging, because it's not a question to have a communication strategy only. You must have an institutional capacity to respond, which in the context of the emergency is not necessarily easy to organize, with the lack of technical support to do telework, to have hearings by internet without physical access to the files. So what I would imagine is a context in which if the rules of the emergency and the fear of the sickness limits really severely the functioning of the judiciary, to take administrative decisions to establish clearly what areas should continue to work and what are the ways and the means through which the public can have access to that means. I was thinking in one example, domestic violence, which in the context of lockdowns apparently has increased worldwide, because there is a sensation of impunity that the victims cannot go to the police station to claim for the aggression. So to establish clear procedures and access of what kind of situations can be matter of a claim through internet, what kind of procedures have to do with the reality of the right to health, labor cases, and so on. So I would think that in any judiciary in the world will be in capacity to establish certain kind of procedures that must not be blocked, that should continue, and that they receive some technical support to work for that. And so that will be obviously the only way through which a communication strategy would have the legitimate to say, well, they are saying those things and they are doing those things at the same time. So that will be absolutely an essential thing to do. But I don't have really a view of what is happening in most of the countries that are here. So this meeting is very, very useful to have this idea in which obviously there is no global standard in which you can say that judiciaries are in that situation now in the world, because every country has its own specific problems. And unfortunately, I don't have a good example of what things can be followed as a model. Unfortunately, in all the new information I receive, I still I am waiting for a model.
No model. Well, Diego, Mr. García-Sayán, we have had now 7 questions from 7 countries here in Southeast Europe. We are a quarter of an hour beyond the time that we agreed with you. So I really don't know whether there is still few seconds or minutes to take the final, or maybe two final questions. It is now upon you to decide.
Okay, maybe we can take two brief questions, one after the other. So because I have other, unfortunately, I am not allowed to leave my house, so I have to have other meeting again in Zoom. The problem is that 2 days ago, internet stopped to work, so it was the end of the world. No? Only for 1 day, unfortunately.
Well, I can see a hand raised by Ion Guzun, and now first comes, well, somebody else would then also have a second, that is final question for this discussion. I'm looking at all of you. Somebody else, a question. Ion, please.
Actually, I've already had raised my question, and probably now you can see, and if you can read my question that I wrote to you, probably that will be better understandable, rather than, as I understood, the communication is not the best now.
All right, then I do have a question indeed. It would be interesting, I think, for everybody to hear your view about online trials. Online trials, just from the perspective of trial lawyers as well as judges. Have you looked into that matter? And if yes, can you share some thoughts about that?
Well, and the question of Ion is a very good question. It has a recommendation. If the rapporteur has imagined to set a recommendation regarding conduct of hearings, is a connected question. No? The standards that we must consider has to do not necessarily with independence, no? Because the independence of the justice system is that the one that should imagine how these online hearings should take place. That's a very an important matter of principle. No? And of course, the only big recommendation that a rapporteur of the UN could do is that these procedures should guarantee due process. Due process is a question in which the access on time for the files, the access to a lawyer, the right to, in a criminal procedure, to interrogate the witnesses of the other party and so on. So any procedure that limits that access to the facts, the access to the witnesses, access to the accusation, and doesn't give enough time to analyze that, that's a process that would conspire against due process. So it's a very good idea. I think I will open this with other rapporteurs, because that follows other matters as well, because you can imagine what is happening in countries in which there is a big indigenous population, which structurally, traditionally, have had very distant access to public institutions like the judiciary and so on. So in this context, in which physical distance have increased because of the difficulty to move from one place to the other, all that judicial guarantee obviously are suffering very much. But I will follow this very interesting suggestion made by Dion. Thank you. Your microphone, Helmut. Helmut, your microphone. Your microphone.
Oh, it's me with the microphone. Indeed. Yeah. I can see a final question from Stanislav Splavnik. Maybe you want to voice it, and then that is shall be the end of our discussion.
Thank you, Hartmut. I would have a rather theoretical but also very practical question. As we've heard from many speakers, there are lots of examples today where the justice system in more than one country definitely is backtracking, and the crisis triggered by Corona is not necessarily having a direct connection with the measures which cause the backtracking of justice. At the same time, given that the judiciary is normally perceived in theory as well as in practice as the weakest branch of power. And given that, especially in these times, it is important to ensure a strong protection of groups of people who are exposed to vulnerable circumstances, so to say, is it the time to move towards a new militant model of rule of law from an international point of view? Thank you.
Thank you, Stanislav. A very challenging proposition, which at this moment I would say I fully, entirely support. Because as you know, as we all know, this emergency circumstance will last for some time. At the beginning, we thought this would take place for 3-4 months, and that will, at the end of the day, finish. But while the virus is not controlled through one of the severely medical responses that are being matter of investigation and studies, of course, this situation will continue. And the questions that have been raised today express very clearly that there are many new matters that should be dealt in a kind of standards that should be fixed by the judges nationally and by the associations of judges and lawyers. Eventually by multilateral organizations like the UN or the European Council or the European Union. But in any context, I would say, being so important, those multilateral organizations, the decision-taking process in multilateralism is very slow, is not necessarily very enthusiastic with new things and changes, especially in this context of lockdown. So I would give this, not resigning to this task, but I would say that associations of judges and lawyers may play in this process a leading role, because judges know better than anybody what is the daily challenges they have. And what I will do immediately after we finish this meeting, not immediately because I have other meeting now, but later, my day is still beginning, to speak with my friends of the European Association of Judges to transmit them this challenge. If they can begin to work in regional European standards, that can be part of this big debate that faces a challenge that we are facing as a whole in the world, not only for following weeks, but perhaps for the following months and eventually for next year. So, so supporting this process is starting up, and thank you. I will speak with the president of the European Association of Judges, which is part of the Unión Internacional de Magistrados, which is based in Rome, to receive this idea. Very good. Thank you.
Thank you very much. Let me say muchas gracias. As a moderator, in a way, I have failed because it's unfair to all the experts, judges, attorneys, lawyers gathered here to be able to raise only one tiny question. But Diego, if I may say so, you see that the interest in your work here in the region in Southeast Europe truly is huge. And we sincerely hope that you will be allowed to travel, the sooner the better, possibly even in June to Geneva. Then it's not a secret, we're just around the corner from Geneva. It's a short connective flight as soon as flights are back. And we would be happy to host you on an academic visit in several of the countries here. And we have not even exhausted the list of potential questions. Let me say the vetting of judges, which is an issue here in some countries, or may become an issue in other countries as well, etc., etc. I can only offer again that your reports and some of your recommendations, there are so many languages here in Southeast Europe, and not all of them are United Nations official languages, to put it mildly, to also translate some of your recommendations into regional languages so that your work is getting even a larger audience and greater attention. Thank you on behalf of everybody here in our virtual meeting room. Have a good day, working day ahead of you, and we sincerely hope to see you again soonest, and all the best, and thank you again. Muchas gracias.
Thank you very much, Harmut, and really thank you all for your active participation today. For me, it has very, very useful to receive your views, your experiences, the information you are transmitting, and especially the ideas of things that could be eventually suggested to several institutions in the world to improve the situation in these challenges that none of us would ever imagine that we'll be facing in our public life. And congratulations for being very active in this difficult context. And please, all of you, stay healthy and maintain your fantastic positive view regarding life and challenges to judges. Thank you very much, Harmut, for this possibility. Bye-bye.
Bye-bye, everyone.